What's the deal with stepchildren being excluded from wills? While this may seem like the start to a hilarious, well-timed joke, the truth is it can be anything but funny. At this point, it's no secret that society is moving away from the traditional nuclear family. Divorce rates continue to rise, and family structures are becoming more complex. It's just a fact of life. However, this change in family structure is creating some interesting legal challenges when it comes to estate planning, as blended families lead to all sorts of complications in the contested estates arena. Whether you're a stepchild considering contesting a will or a step-parent concerned with protecting your estate, it's important that you are aware of your rights and obligations under the law. In New South Wales, a step-parent can be defined as someone who is not a legal parent of the child, but is married to or in a de facto relationship with a legal parent of the child, and treats that child as a member of the family created with the legal parent. The child in this situation is the stepchild of the step-parent. This step-parent-stepchild relationship can exist even if the legal parent and step-parent are no longer together. So, as a stepchild, can I contest a will in Australia? Well, the short answer is yes, you can. However, the long answer is slightly more complex, as estate law is state-based. Specific requirements and processes associating with contesting an estate vary from state to state. In New South Wales, eligible persons who believe they have been left inadequate provision can make what is called a family provision claim. In New South Wales, eligible persons include current spouse or de facto partner of the deceased, legal child of the deceased, and former spouse of the deceased. However, there is a further category of eligible persons, which is being someone who was dependent on the deceased and lived with the deceased person. If a stepchild can prove that they have met these two criteria, they must then be able to demonstrate to the court that there are factors warranting the application. To do this, the court will consider the unique factors and circumstances of the case, such as the history and closeness of your relationship with the deceased, how old you were when you became a member of the family, and the extent that you were dependent upon your step-parent. Once these factors are established, the court will then look at whether or not you have been given acceptable support by your deceased step-parent. So for example, did your step-parent make contributions to your education or help you with money towards your home or maybe a vehicle? Again, the court will consider all relevant factors of the case, such as the size of the estate, your needs, and the competing needs of the beneficiaries under the will or other eligible persons. Now, in New South Wales, an application for family provisions claims must be brought within 12 months of the death of the will maker. This time limit remains the same, regardless of the category of eligible person that you may fall under. Now, as with many legal matters, there may be things that lead to an application being made out of time. Maybe probate has not yet been applied for, or you weren't made aware of the contents of the will until after the expiry of the time limit. While an out-of-time application can be made in limited circumstances, the circumstances are just that, limited. Applicants should endeavour to act as quickly as possible and seek independent legal advice to avoid unnecessary delays and complications with the process. So let's look at an example. Picture this. You're an adult stepchild and you have been written out of your late stepfather's will. The estate is worth $750,000. As a teenager, you lived with your mother and stepfather and were completely dependent on them for a year. So already we've established that you're an eligible person. You prove to the court that you have factors warranting and that you have not been adequately provided for. The court orders that you are to receive a lump sum from the estate. This example has similar facts to the real-life case of Doshin and Pedisic, in which the adult stepdaughter received $75,000 from the estate. So, as you can see, excluded stepchildren can and do make successful claims on the estate of their deceased step-parents. If you are unsure about your legal rights as a stepchild or step-parent, or whether you can contest a will in Australia, it's important to speak to a lawyer. As I have explained, the grounds for contesting a will can be complex and vary between state and territories. Our contested wills and estates team are experienced in dealing with these matters and can provide you with advice specific to your circumstances. Contact us today for an obligation-free chat about your options.